Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, Minnesota, we get to talk, and by the way, that's usually not a good thing when you're getting talked about on Washington Gun Law. In particular, all the folks in St. Paul, but I know there are other municipalities that may be dealing with this shortly also. It appears that your city is trying to pass its own set of gun control laws. Are you going to freak out? No, you're not. I want you to take a deep breath. Okay, because we're going to talk about state preemption laws, and we're going to talk about the fact that whatever St. Paul and any other of these municipalities are doing under the current state of Minnesota law makes these ordinances not even worth the paper they're printed on. So today, let's spend a few minutes, let's get you educated, and let's talk about Minnesota's very expensive anti-gun virtue signal. Okay, America, and in particular Minnesota, we are going to be talking about the city of St. Paul, who decided on their own, sua sponte, since Governor Tim Walz couldn't even get a special legislative session back into session, that they would just go alone and pass their own gun laws. Now, we already did this video right here because we kind of saw the writing on the wall. And this really doesn't come as any surprise what the city of St. Paul did earlier this week. Their new gun ordinance purports to do the following. Bans the public possession of assault weapons, large capacity magazines, and binary triggers within the city limits. How they're defining public possession, I honestly do not know. It doesn't really matter. The ordinance also allegedly prohibits untraceable ghost guns by requiring all firearms to have serial numbers. Restricts firearms in sensitive public places such as parks, libraries, recreation centers, and city buildings, all of which are probably sensitive places that are not articulated in state law. The ordinance also requires clear signage in public facilities to inform residents of restrictions and encourage compliance, and defines enforcement authority and penalties to take effect only if the state repeals or amends preemption law. Oh, and there is the magic little phrase, okay? Because yes, here's the deal, Minnesota. This is going to be a very expensive virtue signal because the minute this goes into effect, the lawsuits are going to file. And yes, ultimately, the petitioners and or plaintiffs on those lawsuits are going to win. Yet, it's going to cost all of you Minnesota taxpayers a whole lot of money. Why do I say that? Well, because there is a big history of trying to work around state preemption laws, and none of them have ever worked. What exactly is a state preemption law? A state preemption law is a law that says, hey, listen, when it comes to restrictions on firearms, the state legislature and the state legislature alone has exclusive jurisdiction. No municipality, county, town, city, borough, or anything like that can write any other firearms restrictions. Now, I know for some of us, we don't like what our state legislators are doing to our gun rights, but can you imagine if you were able to turn that over to some of the lunatic city and county councils you see around the country? Actually, Minnesota's not that alone in this. There are 42 states that have state preemption laws. They became a big deal in the early 1980s after the city of Chicago decided that they could just pass an outright ban on all handguns, and that kind of led a lot of state legislators to implement state preemption laws. Minnesota's state preemption law, which is found in section 471.633, reads as follows. The legislature preempts all authority of a home rule charter or statutory city, including a city of the first class, county, town, municipal corporation, or other government subdivision, or any of their instrumentalities to regulate firearms, ammunition, or their respective components to the complete exclusion of any order, ordinance, or regulation by them except that. And then, yes, municipalities have some very limited restrictions they could pass. But according to the Minnesota state preemption law, those exceptions include A, governmental subdivision may regulate the discharge of firearms, and B, a governmental subdivision may adopt regulations identical to state law. What does the law say if you decide to do something contrary to that? Local regulation inconsistent with this section is void. Now, I didn't have a chance to do research on every single time someone tried to write a law in violation of a state's preemption law, but the ones I did found, it would seem to show that state preemption laws are in fact completely undefeated. In 2016, the city of Tucson decided that they were going to go ahead and draft the ordinance that said that any firearm that was confiscated had to be immediately destroyed. That case went to court. It was thrown out in the matter of Bronovich v. Tucson. In 2017, the city of Philadelphia felt that they could pass additional sensitive places or gun-free zones, including city parks. That ordinance was thrown out in the matter of GOA versus Philadelphia. And in 2021, the city of Boulder, Colorado decided they could pass their own assault weapon ban. Colorado has since amended its state preemption law, but at the time they had a pretty robust state preemption law. That ordinance was thrown out in the matter of Caldera versus city of Boulder. And then if you want to know just how expensive it can be, let me give you an example from right here in my own backyard in the matter of Bass versus city of Edmonds. The city of Edmonds decided that they could pass their own safe storage provisions here in Washington State. The law was challenged in the Snohomish County Superior Court, where the city of Edmonds lost. They took it then to the Division I Court of Appeals, where they lost 3-0. They then took it to the Washington State Supreme Court, who has never, ever, ever had a problem upholding a gun law. Yeah, except the city of Edmonds, they lost in the Supreme Court by a vote of 9-0. Well, that means that of all the judges they got in front of, their overall record was 0-13, yet they cost Edmonds taxpayers nearly $700,000 in legal fees. For what? For a virtue signal. And that is exactly what's occurred here in St. Paul. And that's exactly what's going to occur in any of these other municipalities. These ordinances may make those people on the city council feel really good, may make some of their constituents feel really good, but I got news for you, Minnesota. They're not worth the paper they're printed on. What is the lesson to be learned from this? Well, Minnesota, it's this. You have to very carefully watch every time your state legislature is back in session, because if they were to repeal your state preemption law, then towns such as St. Paul, Minneapolis, or any of the other cities right here on this list, well, they're free to regulate firearms in whatever fashion they so desire. And are they still subject to legal challenges? Yes, they are subject to legal challenges, but think about how impossible the task gets when suddenly we're having to mount individual legal challenges based upon municipalities, cities, and counties. So, Minnesota, especially for those of you in St. Paul, take a deep breath. That ordinance is not worth the paper it's printed on. Unfortunately, as a taxpayer, it's going to cost you some money. All right, listen, if you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information's down there in the description box. If you got an idea for a video we should be doing around here, you click on that link, you tell us all about it. If you want to subscribe to our monthly newsletter, the information on how to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe. Well, and just to give people the type of understanding of the financial catastrophic occurrence that occurred, you and I are both privy to people who have been involved in lawful self-defense situations, pulled the trigger with legal justification, faced potential legal consequences, and had to fight for their freedom. Didn't have coverage. How much money did it cost them to win their freedom?
You know, I really don't think that people really can grasp, you know, the magnitude of expenses. You know, most recently, and you and I have talked about this in the past, the Kyle Rittenhouse case brought a lot to light.
Right to bear, that's right. Legal protection for self-protection. Listen, good lawyers aren't cheap. Cheap lawyers aren't good. You're not truly prepared unless you have right to bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.